Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are on the record calling for pretrial, our first pretrial, case number 2114861, Dwayne Miles versus City of Detroit, your respective appearances.
Good morning, Your Honor. Matthew Ross on behalf of the plaintiff, P78174.
Good morning, Your Honor. Lauren Amy on behalf of the defendant, City of Detroit, P80726.
Okay. First of all, have we made our 2.3028 disclosures? Silence.
No, Your Honor. I don't. They were not court ordered at this time, correct?
That's wrong.
Oh, they were court ordered.
Do you have a notice that brings you here today?
Let's see. Yeah, obviously, yes.
You see the box that says other?
Yes.
What is stamped there?
The initial disclosures. Okay.
Your Honor, if I may step in for a second.
Sir.
We could provide the initial disclosures, both parties can, Your Honor. This case, and I spoke to opposing counsel yesterday on this, it's all of $1,000. We have made a request to both the sole provider bill as well as the subrogation lien. And it's our intention, pending how long it takes subrogation to get that balance back, to submit a demand to opposing counsel. And it's myself and opposing counsel's goal, probably within, if the court would be willing to extend, maybe adjourn 90 days, we should be able to resolve this between now and then, Your Honor.
You couldn't comply with a 21-day order. Why would I give you 90 more days?
Actually, sorry, Your Honor, to interject. I believe we both did comply, actually. I'm just looked in my file and it looks like we did file the disclosures, the initial disclosures.
Mr. Ross, did you file yours?
I would be shocked if we didn't, Your Honor. I guess I was more so just stepping in to support opposing counsel on this.
Okay.
I see yours as well, actually. So, Your Honor, both parties have filed our initial disclosures.
Okay, next suggestion. Perhaps a little preparation before you appear at pretrial would be in order.
Yes, Your Honor. Yes, brother counsel and I have discussed the matter, and we're actually coming here today to request an adjournment because we think we can resolve the matter.
I'll give you.
We're just waiting for some pending. Sorry.
I'll give you 30 days. We'll see where we are. We need to move on this file, or I mean, if it's not a big file, and you both seem to think it's not, this is the kind of thing that should be killed very quickly. You kill your small files quickly as you can, with as minimal effort as you can, and move on to fry bigger fish.
That's absolutely our intention, Your Honor.
Does April 29th work for both of you?
April 29. April 29th is fine with my calendar.
What about you, ma'am?
Yep, that works, Your Honor. Thank you.
April 29th at 10 o'clock, we'll do this again. And let's get moving on killing the file.
You got it, Your Honor. Thank you very much.
So we all know where we're going here. All we're arguing about is when we're going to get there. Let's get it done, y'all.
Thank you, Your Honor.
Have a good day.
Thank you, Your Honor.
Be safe.
Bye-bye.
We are on the record calling file number 211478882, Westlake Services versus Richard Brown, Tierra Ammons. By notice dated February 23rd, 2021. This matter is set for Zoom pretrial today, March 25th at 10 o'clock. It's now 10:31. What is your name, sir?
Richard Brown.
Mr. Brown is the only party to this litigation who has appeared. Plaintiff has failed to appear. The defendant Ammons has failed to appear. This case is dismissed without prejudice. Sir, we'll send you out in order. Thank you for coming in. We're off the record.
Thank you.
Have a good day, sir.
You too.
We are on the record calling file number 19179-032. This case is entitled Jefferson Capital System versus David Banks. By a notice dated March 1st, 2021, this matter is set for hearing today, March 25th at 10 o'clock on the plaintiff's motion to amend judgment. It is currently 10:31. Your appearance.
Kara Bailey, P73071 on behalf of the plaintiff today.
Ms. Bailey, the defendant has failed to appear. The defendant filed any pleadings in this matter.
No, not that I'm aware of, Your Honor.
All right, in relationship to your motion, go ahead, please.
This is a motion to amend our judgment. Unfortunately, we had a clerical error for about a week where everything was printed right except for the total amount of the judgment. So the damages are right, the court costs are right, but they didn't add up correctly. So we caught that error, fixed it, but we had several judgments that were entered during that time period, and we had to file motions to amend those judgments.
Well, the problem that I have here is that this is really not this is a clerical error. And I'm looking at your proposed amended judgment, and it is consistent with the relief sought in your complaint initially. The plaintiff has appeared, the defendant has failed to appear. Plaintiff appears to be entitled to the relief sought. The unopposed motion to amend your judgment will therefore be granted. Have a nice day.
Thank you, Your Honor. I have at 11 o'clock, so I will see you then.
Okay, we'll see you then at 11. I'll put you back in the waiting. You want me to let you remove you or
I'll
put you
just
in the waiting
sign back in. We still got a half hour, so.
room? Okay, I'll put you in the waiting room then.
Okay.
All right, thank you. All right. Back again, Ms. Bailey.
Yep.
Jefferson Capital System.
Yes, versus Charlize Tucker.
Got it. Off to the waiting room with you.
Morning, Your Honor.
Good morning, Ms. Dixon.
Yes, Your Honor. I'm here.
Where'd you go? Oops, I think
You send her to the waiting room.
I said,
instead of me?
yeah, I sent her to the waiting room. All right, let's see if I can get this right. One thing at a time. First, Ms. Bailey to the waiting room. And now, Ms. Dixon, why are you here today?
Your Honor, I'm here for the behalf of Plaintiff Westlake Services, LLC. This is case number 2016-7622.
Uh-oh. I don't have a Westlake case today at 11 o'clock. Are you
Oh.
sure you're in the right place?
Your Honor, I mean, this was what was given to us as far as because
Give
the
me-
judge.
Give me the case number.
Sure. The case number is 2016.
2016
Yes, 7622.
76. All right.
I guess.
I think you got the wrong. Let me check with my clerk and see if we
Okay.
can figure this out for you.
Thank you.
Ms. Dixit, my clerk
Yes.
seems to have stepped away from her desk, but I do not have you on my calendar for today. The only
Oh.
Westlake case that I had today was at 10 o'clock.
I see.
Now it's a
Yes,
different.
Your Honor, yes, I did double check. I mean, yeah, it says March 25th at 11 a.m. It was a pretrial. I didn't see a judge name on here. It didn't say.
I don't believe it's my file. You may have
Well,
it, but it's with someone else.
yes, sir. So I do see the notice, and it actually provided this with the Zoom hearing. It says courtroom 539 and provided the phone number before Judge David S. Robinson Jr.
539 is my courtroom, and I am that judge. Just let me put you in the waiting room and see if we can figure out. Okay.
Thank you.
All right. All right. Let's see what we got. What brings you here, counsel?
Your Honor, my name is Ryan Heeman. I represent Farmers Insurance Exchange in our subrogation complaint against Victoria Hainsworth 20151238-GC.
Okay, I don't have your opponent as of yet, so I'll put you in the waiting room.
All right, thank you, Your Honor.
Mr. Buchanan?
Hi, Judge.
What brings you here?
Brandon Buchanan on behalf of Lock Automotive. I'm the represent the defendant.
Okay, I see you.
I don't know if opposing counsel.
I don't have your opponent as of yet either. So you're
Okay.
in the waiting room.
Well, it's good to see you, Judge.
Good to see you too.
Good to be seen.
Rather than viewed, I know that's right.
Yes, sir.
Hello, you have reached 36th District Court.
Ms. Dixon, you're not on my docket today because this case was dismissed on March 23rd.
I see. Was it scheduled for that date by any chance, on the 23rd, the hearing, instead of the 25th?
It looks like there was a Zoom hearing on that day.
Okay,
And only defense counsel appeared and the case was dismissed.
I see. Okay,
So you're 2 days late.
okay. Yes, it was on our calendar for 25th, but I do see the notice, and I think it was seen as the 25th instead of the 23rd. So I do apologize for that, Your Honor.
No problem.
Your Honor, if you don't mind me asking, how should we, you said the case was dismissed?
Yes, it was a pretrial and the plaintiff failed to appear. Case is dismissed.
Okay,
The order should be coming in the next couple of days because we mailed it on the 23rd.
okay.
Okay, have a good day, counsel.
Okay, thank you, Your Honor. I apologize.
No big deal. Not the end of the world.
Thank you.
Mr. Buchanan, I think your opponent has arrived.
Okay,
So he filed a motion asking for a status conference.
hold on.
That's what they got.
We back in. We back in.
Okay, bye.
All right. We are on the record. This is file 20162-755. Corrigan Towing versus Lock Automotive. Date and time, well, not the time is 10 o'clock. But anyway, date for a pretrial, your appearance.
Brandon, I'm gonna let counsel go first. This is on his motion.
Mr. Conti, are you there? Mr. Conti, are you there? I have his picture, Mr. Buchanan, and that's all. I'm not getting a response from him. So I guess it's back to the waiting room.
Okay.
Mr. Conti, are you there? Just to him right now. Let's do it right now. We are on the record calling file number 20151-238, Farmers Insurance Exchange versus Victoria Hainsworth. This is the date and time for an adjourned motion for entry of default judgment. Your appearance.
Ryan Heeman, attorney on behalf of Plaintiff Farmers Insurance Exchange.
Okay. Counsel, I've had a chance to review your motion, and I have determined, based upon your pleadings, that the district court has lacked subject matter jurisdiction here from the beginning. In paragraph 3 of your complaint, you state, or should I say your client states, quote, that this is paragraph 4, excuse me, that the amount of controversy is within the jurisdiction of this court. That's $25,000. However, in your motion, in paragraph 11, you say that as of January 22nd, 2021, the date of filing of your complaint, plaintiff had paid and incurred $49,427.73 in PIP benefits. At the time you filed your complaint, your statement that the jurisdiction lay within the 36th District Court was factually inaccurate. Further, as is made clear in Charles Moody versus Get Well Medical Treatment and Homeowners Court of Appeals case from February 2014, the implication of your argument is that subject matter jurisdiction may be conferred by artful pleading, and by limiting a judgment to the district court's jurisdictional limit violates the principle that the parties to a lawsuit cannot confer jurisdiction on the court that it does not have, and says nothing to the offensive notice that one merely says the magic words to confer jurisdiction where it otherwise would not exist, citing In re Hatcher 443 Mich at 443. This case should never have been filed in the district court. Your claim and your complaint that the district court has subject matter jurisdiction flies in the face of your request for default judgment, where you admit that at the time of the filing of your complaint, you had paid more than $49,000. Therefore, on the authority of Moody, I have no choice but to dismiss your matter without prejudice. I lack subject matter jurisdiction in this matter. Court will send out an order to that effect. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
Your Honor, if I may, before, can I respond, please? Because actually we filed this complaint on April 2nd, 2020. And at that time, we had only paid PIP benefits in the amount of $10,076 to or on behalf of David Hainsworth, who was the passenger and defendant Victoria Hainsworth. As
At-
such,
At what time did you pay more than $25,000?
from the time that we filed the complaint, by the time we filed our motion for the default judgment, as
Yes.
demonstrated by our payment log. So we spoke with our client, and instead of dismissing the claim from your honorable court, we decided just to go up to the jurisdictional limit that you are able to provide for us. So we thought it better just to keep it in your court instead of filing an entirely new lawsuit because of judicial resources. So at the time that we filed our motion, yes, at that time it had been above it, we had paid above the amount. However, we had made a decision just to ask for an order within your jurisdictional limits.
But the problem that I have, counsel, is there was a substantial lag time between the time you filed your complaint and the time that you came for your motion. Looking at your log, when did your payments exceed $25,000?
It looks like that would have come closer to the end of 2020.
Closer to the end of 2020.
Correct, because of large payments to rehab facilities that David Hainsworth.
So then by the time this motion was filed, clearly the court no longer had subject matter jurisdiction. Fair to say?
Your Honor, that is fair to say, which is why we didn't ask for any more than what your subject matter jurisdiction is.
You can't produce what you're doing here. You can't provide proof of damages in excess of your court's jurisdictional amount and then say the amount of controversy is within my jurisdiction. Your matter is dismissed without prejudice. You have an absolute right to appeal my decision. I'm relying on the Moody versus State Farm decision from 2014. Thank you for coming in, counsel.
Thank you for your time, Judge. Have a great day.
Okay, you too.
Thank you.
We are on the record calling file number 20142-925, Jefferson Capital System versus Charlize Tucker. Your appearance, please.
Kara Bailey, P73071 on behalf of the plaintiff today.
Ms. Bailey, this matter is set before a motion to amend the judgment notice dated March 1st, 2021, set for hearing today, March 25th at 11. It's currently 11:39. We have not heard from the defendant Tucker in this matter. If you would proceed with your motion.
Yes, Your Honor. As I stated in a previous hearing, unfortunately, we had a computer glitch that caused judgments to be printed out with the wrong total damages. The principal damages, the court costs, and the statutory attorney fee is all correct. They just didn't add up right for the total amount of the judgment. Therefore, we are asking to amend our previously submitted judgment.
On review, counsel, your amended judgment provides for the same amount of damages that were claimed in your complaint. Your unopposed motion to amend the judgment is therefore granted. Thank you for coming.
Your Honor.
Did you fix your computer glitch?
Yes, we found it out like about a week or two after,
Really?
Unfortunately.
Wow.
But yes, it was fixed at that time. We just had a bad.
How did that happen?
An update to the computer system appears to have caused it. It was only one client's files that for some reason did it, but it seemed to have happened right after a big update to our program. So
much for
computer. It's as much of a pain for me as it was for you, Your Honor. So I apologize for that.
Have a good day.
You too.
Bye-bye. All right, we are on the record calling file number 2016275. The file is called Corrigan Towing versus Lock Automotive by notice dated March 3rd, date and time set for pretrial. This matter, I've been called on 2 occasions. I have a picture of Mr. Conti, but oh, there he is. Your respective appearances.
Good morning. I'm sorry. I wasn't getting audio.
Your appearance.
Good morning, Your Honor. Guy Conti on behalf of Corrigan Towing.
Bar number.
P68889.
Counsel.
Good morning, Your Honor. Brandon Buchanan appearing on behalf of Lock Automotive Group, pro bono, P number 67499.
Okay, we got a problem here. Your pleadings describe your response as a complaint for divorce. Obviously, I lack subject matter jurisdiction. Divorce. What's going on, Mr. Buchanan?
Say that again.
Your pleading.
Oh, no. I did an amendment to that pleading. So I don't know if you don't have it or not. But I did a supplemental answer that divorce is not a part of this. So I've properly filed that. Your clerk has it.
Mr. Conti, have you received that amended response?
Your Honor, I don't believe I have, but if Mr. Buchanan will email it to me, I'll accept it that way. It's no big deal.
Okay, because I don't have it either. What I have is I have a motion for status conference filed by Mr. Conti. I have no pleadings from you, Mr. Buchanan, after the court issued its order describing it as lacking subject matter jurisdiction because this was a divorce case.
Well, we actually did. So I don't know what has happened, but we actually filed it, and I will get that to the court. It's not a problem.
And get it to Mr. Conti as well.
Sure.
So I take it we've done really nothing in terms of moving the file forward, given our pleading problems.
Correct, Your Honor.
All right. What I'm going to do then is I'm going to give you gentlemen another date and we'll move forward on this. Does April 29th work for both of you?
That's fine for me.
Mr. Conti?
1 second, Your Honor. I'm looking at the calendar now.
Got it.
While Mr. Conti is looking up the calendar, Judge, I would be a motion in the court to issue a discovery order. Back in last year in November, I issued first set of interrogatories to Mr. Conti. Obviously, the court had not at that time issued a discovery order. So therefore, Mr. Conti, rightfully so, said I don't have to comply with this because there's no discovery order in place. Well, now that we're at the first pretrial, I'm asking for that to be entered so that we can do something, because I can't have any meaningful conversation with Mr. Conti or yourself regarding this case until some questions have been answered.
Conti, April 29th, day work?
Your Honor, April 29th works. I have no objection to discovery. I just generally want it on the record so that if I have objections to discovery, I can properly serve them on Mr. Buchanan, meaning on individual items of discovery.
This is what the court is going to do. I'm going to set this matter for pretrial April 29th at 11 o'clock. I will open your written discovery as of this time.
Yes, Your Honor.
Let's get our pleadings in order. Let's get started on moving this file. We spent a great deal of time here doing nothing.
Yes, Your Honor.
Is there anything else to say, gentlemen?
Not from plaintiff, Your Honor.
All right, April 29th at 11 o'clock. Your written discovery is now open. Thank you.
Thank you.
For coming in. We're off the record.
Thank you, Your Honor.